The following is a paid program. Advice and opinions expressed during the program are solely that of Melick Law, not WBEV or Good Karma Brands. Good morning and welcome to a Melick Monday here on your hometown station, 95.3 WBEV, powered by Daily Dodge. Amy Hudson and Rob Melick in the Slumberland Furniture Studios and also the Daily Dodge TV studios. Good morning and welcome.
Good to see you, Amy.
You were the very first partner or guest that we had in the Daily Dodge TV studios, and you rocked it. Can you believe that was just about a month or so ago?
It was. It's moving quickly here, but it's something new, that's for sure. But I enjoy it. So
Yeah,
it
me
works out
too. So glad that you're here with us today. Of course, you join us the third Monday of every month, and we talk about big things that people shouldn't be intimidated by because what you do at Melick Law is help people with their estate plans and make things that are, difficult for them to understand easy to understand. So we have a lot to talk about because you say, I think almost every show, that estate planning is a topic most people choose to ignore.
It is. I've found that, 17 years of experience, it's just not something people want to talk about. I mean, there's a lot of legal matters people don't want to talk about. I mean, divorce, personal injury, criminal defense. So I always say there's a reason those lawyer jokes exist, right? People don't like seeing lawyers in general, but I try to take this experience and make it as, I don't want to say enjoyable, but as painless as possible, I suppose, because it is something that we need to do. I mean, Again, drawing a distinction between other areas of legal practice, Amy, not everyone's going to need to see a criminal defense attorney, right? Not everyone's going to be convicted or accused of a crime. Not everyone is going to go through a divorce or have a personal injury, but every single one of us is going to pass away at some point. That's an inevitability. I always jokingly say that until they come up with a mortality pill, or an immortality pill, excuse me, I have 100% mortality rate, and I'm going to be employed for a long time. So it's just something that people need to get done. And again, it's one of those things where if you ask just a random person on the street, hey, what do you know about estate planning? They're going to say it's something that needs to be done, but it's something that, we can get done later, or we'll wait till we're older. Well, as we all know, we don't know when we're going to pass away. We know what's going to happen, but we don't know when or under what circumstances. So what I always encourage my prospective clients to think about is once you get that estate plan, you have that peace of mind for the rest of your life. Why not enjoy that peace of mind for as long as possible by having that plan? And that plan can change over time. One of the things I've talked about on this show is what I call the 3 Ds and a B: death, divorce, disability, and birth. Those are 4 life events that I've found oftentimes will cause people to want to update their documents. And again, we have the ability to do that. Just because we create it in time one does not mean we cannot change it in time two. When those life events or other events occur, not only do we have the ability to make those changes, but at my firm, Melick Law, we don't charge for those revisions. So if you do your initial estate planning documents with me, those life events occur, we have the ability to make those changes on a complimentary basis.
It's really nice. Rob Melick of Melick Law is with us here this morning. Rob is your hometown lawyer and happy to take your calls, your texts. If you have a question, you need some advice, certainly give us a call at 885-4446. 885-4446 is our studio line. And you can also text at 887-9595. 887-9595 is the studio text line. Did you have a nice Father's Day?
I did. It was fun. We went to breakfast with my dad in the morning, so I got to see my sister and my soon-to-be 3-year-old niece. So I got to spend some time with her. And like most soon-to-be 3-year-olds, she was a little restless. So at one point I said, all right, I'll just take her for a walk. We walked around the restaurant. I held her hand as we walked around. So she enjoyed that. It was good to spend some quality time with my niece and, of course, my 2 sons. So that was good. And then the 4 of us, my wife and my 2 boys, we went to a Mongolian barbecue place. So
that sounds really good.
It was really delicious. Yeah, it's one of those, I don't know if you've heard of hot pot before, where they actually have it on the table. So they bring you the meats and you actually cook them at the table. So it was delicious. Probably ate too much, but it was really good. The boys enjoyed it. My wife likes that place, so it was a good time.
When you wheeled into the Daily Dodge TV studios just a few minutes before we were getting set to hit the air, I was like, "Wow, you look very nice today. What is happening? You always look nice, but you're a little spiffed up more than usual."
Yeah, I try not to get too dressy as an attorney. I still don't have the tie on or anything, but yeah. So basically, long story short, the reason I'm dressed up today is because I'm actually going to be in a newspaper article. They're doing an article on my law firm. We recently purchased an office in Saukville, so I'm still going to maintain my Beaver Dam office. Sandy and Matt generously let me use their office there, but my main office, I bought the building on Friday, so we closed the building on Friday. We'll be in Saukville, so yeah, it's a slow kind of rollout. We still have our lease, but we're going to be probably occupying the Saukville building probably in mid to late fall. And the Ozaki Press, the local newspaper, wants to do an article about our firm and the purchase of the building. So I figured I would at least somewhat look the part. I'm not going to put a tie on, but we reserve that for graduations, weddings, and funerals. But beyond that, trying to look a little more dapper today. So doing what I can here.
Well, that's fantastic. Congratulations
Thank you.
on the new building. You're welcome.
I'm excited. It's one of those things where it's every business owner's dream to purchase a building. You lease space and lining your landlord's pockets as opposed to building equity in a place. It's no different than buying a home. So the right building came up, had the opportunity to purchase it, got lucky enough to get the accepted bid, and I'm now a commercial building owner.
All right. That is super exciting, and I look forward to reading the article and seeing your picture in there when that comes out. So make sure you bring me a copy, or I'll just, head over to Washington County, right?
Ozaki County.
Ozaki
yeah, it's
County.
the Ozaki Press, but and I'm having my 3 paralegals in the picture too, so they're include all them in there, and yeah, it'll be fun. So actually, right after I get done recording this, I'm gonna head east and meet with them and see how it goes.
That's fantastic. Rob Melick, your hometown lawyer of Melick Law, is with us here this morning. 885-4446 is the studio line, and our text line is 887-9595. If you have a question for Rob, if you need some advice on a certain situation that you're in, I tell you often that you have a gift for making big things seem less big, not so intimidating, and you really do a great job of simplifying things, because it is hard to think about your final wishes and how you want to leave things behind for your family. And an estate plan really is critical. It's crucial to all of those things. So, and it's also not something that is just for older folks.
No, I mean, one of the things I say anytime I do a radio show or any sort of public speaking engagement is that anybody over the age of 18 should have an estate plan. Now, when I speak to a large enough audience, inevitably I'm going to get an eye roll or two. It happens. And people say, well, why in the world do you believe that? Well, like any good lawyer, I'm going to defend my argument here. So the defense of the argument starts here. Once someone reaches the age of 18, they are legally considered an adult, okay? And that comes with some rights and some responsibilities. For instance, the ability to vote in elections, right? Someone turns 18, they have the ability to do that. They can enlist in the military. They can do any number of things. But for my purposes as an estate planning attorney, the biggest thing there is that the moment someone reaches 18, they are now protected by what is called HIPAA. And again, I'm sure most people listening have heard of HIPAA before. HIPAA is an acronym. It's a federal law that stands for the Health Insurance Portability and Accountability Act. Basically what it does is it sets parameters regarding when and under what circumstances medical professionals can share your medical information. Now, as a general rule, we don't want that information shared, right? We want to be able to confide confidently in our medical professionals so that we can share our conditions and we don't have to worry about them, providing that information to people we don't want them to provide it to. The problem is that we can't really distinguish when and who gets that information. The law doesn't provide for that. So the example I always give is this. The average 18-year-old in the state of Wisconsin is still in high school. I can tell you that, obviously there's a trend in education to push people back as far as when they graduate. Again, by way of full example, just based on when I was born in the calendar year, I was born in July, so I graduated high school at 17. Well, anyone with a summer birthday is going to be in that same position, but most people are not in that position. In fact, if I was in school now, I probably would have been 18 turning 19 before I graduated high school. So the idea is that most 18-year-olds in the state are still in high school. I can tell you that my boys will be in that situation. I have one with a September birthday. I have another one with a February birthday. So they're going to be 18 for a good portion. And in Hudson's case, my youngest, the entirety of his senior year. He has an early September birthday. So what does that mean? That means the moment a child turns 18, they have HIPAA protections. What does that mean from an estate planning standpoint? Here's the hypothetical I've walked through thousands of times in my legal career. That 18-year-old drives to school. That 18-year-old goes to a movie theater over the weekend, whatever the case is. And let's say they're involved in a horrible car accident. The accident is such that they no longer have the ability to receive and process information. Perhaps they are in a coma. They are taken to the hospital. Now, keep in mind, this 18-year-old in my hypothetical is still a senior in high school, is still living at home. However, as parents, those parents of that child have neither the right to receive information regarding that person's condition nor the ability to make medical decisions, because without the ability for that 18-year-old to give that authority to their parents, parents do not have that authority. And if that person's in a coma, they can't give that information. Now, to compare and contrast it, let's say they're in a car accident and they have some bruises and some bumps, maybe a broken arm, they're taken to the hospital. Sure, they can verbally convey, hey, call my mom, call my dad, give that information out. That's fine. But if they don't have the ability to communicate that, hospitals can neither share that medical information nor allow those parents to make those medical decisions. So as a parent, that's a pretty scary proposition. So we want to make sure we can avoid that by having your children have those powers of attorney the moment they turn 18. So that's something that, again, as a first-generation lawyer, that's something I really emphasize. And as a parent myself, I mean, we're at 14 and 11 here for my two boys. They're quickly approaching that age 18 mark, and I can guarantee you the second they turn 18, they're signing those documents. And every parent, every grandparent should similarly encourage their children to sign documents for their kids as well, because it's going to happen. They're going to get to that point, and we need to make sure that they have the documents in place. Now, fortunately, this doesn't happen to a lot of people. But one of the things I always say in my practice, while this is an unlikely event, unfortunately, it's not a 0% event.
Right.
It's somewhere north of 0%. It's going to happen to someone. If it happens to you, unlikely as it may be, there's very easy, quick, and inexpensive ways to make sure that you as parents have the ability to make those medical and financial decisions, and that's by creating financial and healthcare powers of attorney. I threw that word financial in there. People might say, well, my 18-year-old, Rob, I see what you're saying about the healthcare power of attorney, but my 18-year-old has a summer job and that's it. It doesn't have much by way of income. But when it comes to a financial power of attorney, it's not necessarily just the amount of money they have. Basically, it's anything but healthcare decisions. So, for instance, the ability to communicate with a high school or a college regarding that person's status, to deal with insurance companies, even though you're the insured or you're the one providing the insurance, they're the insured. So, without a power of attorney, you don't have the ability to communicate with them unless you have that financial power of attorney in place. So, that's the basic set of documents that I recommend anyone over the age of 18 get. Furthermore, with powers of attorney, another misconception that we run into is that people think spouses automatically have that authority.
Yeah.
That's another big one, right? And what I always say is this. Again, let's say I did anything else other than what I did for a living. I mentioned I'm driving to Saukville here after the conclusion of the show. Most of the way is going to be on Highway 33, 55-mile-an-hour divided highway. Someone coming toward me has a stroke, has a heart attack, they lose control, hit me head on, okay? What happens then? I'm taken to the hospital, I'm in a coma. If I don't have powers of attorney, my wife not only can't make medical decisions for me, again, she cannot even receive any information regarding my care because I cannot provide the consent to share that information with my wife. So married couples need to have that because most people would say, well, it's my spouse. Of course I can make those decisions. No, you can't. First of all, HIPAA doesn't carve out exceptions. And there are a lot of people, and we don't have to name names here, but there are a lot of people who I know personally and professionally who wouldn't want their spouse to know. Maybe they're only staying together for the kids. Maybe they're on the path to getting divorced. Maybe they're sticking together for religious reasons. I mean, the divorce rate in this country is over 50%. So there's any number of people who may or may not want their spouse to be the point contact person or even know about that person's medical condition. So medical staffs cannot make exceptions for that. So again, if you're married and you think, well, my spouse automatically has that decision-making authority, they don't. Part of creating any well-drafted estate plan for anyone over the age of 18 are those powers of attorney. Now, there are things we do beyond powers of attorney, wills, trusts, things like that. And the need for those documents is really dependent upon a lot of factors, whether you have minor children, whether you own real estate. There's any number of factors that go into the decision about whether to create a will or a trust. We could certainly go into those later in the show. But when it comes to the powers of attorney, it's really a non-discussion. If you're over 18, you need to have those powers of attorney. If you're under 18, it's no problem. I mean, my two boys right now, under 18, something happens to them, we as parents, my wife and I, can make those medical and financial decisions, no problem. But again, the moment they turn 18, we lose that ability.
Rob Melick of Melick Law, your hometown lawyer, is with us here this morning. So everything, I was going to say so much, but everything that you just shared right there is, pretty rattling because it does affect people's lives. And when I think about my two beautiful daughters, it's like we have to giddy up. So anyone who's driving right now, sitting in their office, just listening, what number should they call, and how do they put things in motion, Rob, to meet with you to have that conversation?
Absolutely. So the best number for any of my offices is 262-347-3444. Again, 262-347-3444. For most people in the listening and viewing audience, my Beaver Dam location is probably the most convenient. Again, Matt and Sandy allow me to use their office to meet with clients right in the Heritage Mall there. But I do also have offices in Richfield, Port Washington, and West Bend. It's always a free initial consultation. Again, I've been doing this long enough to know that people are going to put up any barrier, any hurdle they can to meet with an estate planning attorney, so I do not want cost to be one of the reasons. So I always offer free initial consultations, and I'm happy to have that meeting anywhere and really through any venue. I do make house calls. I do have the ability to meet at homes if people have incapacity issue, or I'm sorry, if people have mobility issues, if people would simply rather meet at their home, I'm happy to do that. I'm also happy to do virtual visits, whether it's by Zoom or phone call or FaceTime, whatever the case is. And furthermore, I do offer a 20% discount to WBEV listeners. So if you do decide to give me a call because you heard me here or you saw me on dailydodge.com, I do afford a 20% discount off of legal services. So please mention that is in fact where you heard me or saw me, and we'll happily apply that discount. But again, that number is available 24/7, 262-347-3444. I'm available by call or by text. Again, as a millennial, I'm used to texting. I have a lot of clients who are much older than millennials who still text, which is great. Whatever method is the best way to get a hold of me, and someone from my office, either myself or one of my 3 paralegals, will get back in touch with you quickly to get that appointment scheduled. As far as what that initial consultation looks like, as I mentioned, it is always free. And that applies whether you fall into one of 2 camps. I always say every single one of my prospective clients falls into one of 2 groups. Group 1 are the people who have existing estate plans, and they either know or they want to know that those documents are either adequate or inadequate. So what I do for clients in that position is I give a complimentary review of the documents. I call it telling the story of your estate plan. So somebody presents me with a set of estate planning documents, and I say, okay, I'm going to very quickly, I don't read every word, of course, because we'd be there forever in some cases, but with all due humility, having done this for a while, I can kind of synthesize what I need pretty quickly. And then what I do is I say, okay, I'm going to tell you the story of your current estate plan. Where you don't like where this story is going, tell me, because either A, things may have changed, or B, perhaps your previous attorney either didn't do a great job of explaining it or you forgot how the previous attorney explained it. So I tell that story because I always tell my clients, doing nothing is always an option. It may not be the best option, but it's always an option. So it could very well be that your existing documents are fine. If they are, I give you that seal of approval, say, great, best of luck, your documents look great. On the other hand, if there are things in the documents that you don't like or have changed over time, then I can identify those for you as well, and then you can decide how you want to adjust the documents accordingly. Because again, just because I, as the lawyer, make a suggestion doesn't mean you have to take it. I mean, the example I always give is this, and I feel like this is a pretty universally relatable example. I'm big on analogies, by the way.
Yes, you are.
I think people tend to understand those better. I think most people in the listening audience can relate to this one. You decide to go to a company to get your oil changed, Jiffy Lube, whatever the case is. You go there, you find the oil change special, whatever it is, and they put it on a rack, they change the oil. Well, inevitably, when the car is done, the mechanic comes out and identifies other issues with the car. Mm-hmm. Hey, your air filter's a little dirty. They'll even show you the air filter, how it's a little dirty. Yeah. Your brake pads are a little worn. Of course, they're going to charge you to replace those things. Well, as the consumer, you don't have to accept what the mechanic's telling you. I mean, the mechanic is speaking from a position of experience. Clearly, they know what they're doing. They're giving recommendations. You hope they're being honest with those recommendations, but you're not required to take those recommendations. In fact, I'd argue most people don't take their recommendations. It's really no different with your estate planning attorney. I'm going to identify for you things that are either legally or preference insufficient. I'm going to identify a price to correct those things. It is, of course, always up to the client or the prospective client to determine whether or to what extent they accept my recommendations. So I identify the issues, you determine whether or not you want to fix them. So that's what I do for my clients who are in boat one, okay, the people who have existing estate planning documents. On the other hand, I have a lot of clients who either A, do not have any estate planning documents whatsoever, or B, they already know that the existing estate planning documents are inadequate or need to be updated. And if that's the case, then we go through what that looks like. I explain on a personal level, okay, look, here's what we want to accomplish with your estate plan. Here are the differences between will and trust-based planning. Identify those issues, come up with a price, and then go from there. One other thing I will say about my practice, Amy, is I do not charge for revisions to documents. Now, to be clear, in that first scenario, when people come to me, another attorney drafted the documents, they want me to revise them, yeah, I charge there because I didn't draft the initial documents. But if somebody drafts a set of documents with me, times change, they want to update things, those revisions are done on a complimentary basis because life happens. I mentioned earlier the 3 Ds and a B: death, divorce, disability, birth, let alone any number of events. I mean, I challenge anyone in this listening audience who, let's say, is over the age of 40, okay? Because if you're too young, it probably won't work. If you're too old, this may not work, but like right around the age of 40, look back on your life 20 years before. If you had created an estate plan set of documents 20 years ago, would it be the same as it is now? Probably not. Look forward 20 years. Do you think your estate planning documents are going to be the same? Probably not. I mean, I'll look at myself. I'm going to be 43 in a couple weeks here, okay? So 20 years ago, I was 23. I was in law school. I was engaged at the time. I wasn't married. I got engaged pretty early, but certainly didn't have children. Wasn't married, nothing like that. 20 years from now, I hope to have grandchildren by then. My 2 boys are 14 and 11, so maybe I have grandchildren by then. My point is that life circumstances change all the time, and we want to make sure the documents reflect that. And one thing I've chosen to do in my practice, Amy, is I've chosen not to have my clients be stuck between having an inferior, out-of-date estate plan or having to pay the cost to update it when they create it through me, because those changes are done on a complimentary basis.
That's really nice. Your hometown lawyer, Rob Melick of Melick Law, is with us, just like he is the third Monday of every month, ready to help you get things in order. Rob is an estate planning attorney, and you may certainly reach out if you have questions or you need some advice. Give us a call at 885-4446, 885-4446, and you can also text at 887-9595. 887-9595 is the studio text line. This is a paid program. Advice and opinions expressed during the program are solely that of Melick Law, not WBEV or Good Karma Brands. Oh my goodness, that's a lot of serious stuff, Rob, but a lot of necessary stuff for people to, be thinking about and to put in motion, because when you're in a situation, I think I've heard you use this analogy, or perhaps it was our friend Matt Heyer. It's much like if you have a car accident, you can't get car insurance then, like right after that accident for that car.
Yeah, I think that's probably a Matt expression there. I agree with it, but I can't take credit for it. But yeah, I mean, we can't do estate planning from beyond the grave. That we can't do. So, I have a lot of clients who time passes and they regret it. And unfortunately, people get these diagnoses sometimes, and oftentimes that's what causes people to go forward with it. And that's, one of the more difficult aspects of my job. I visited ICUs, I visited emergency rooms, I visited hospice facilities, I visited people who are receiving home hospice. And the key thing there is they have to be lucid, right? I mean, again, obviously I've never experienced this directly, but just based on what I've seen through my experience, both personal and professional, cancer is an example. I have a lot of clients who are cancer patients, stage 4 cancer. They're in pain. They're in a lot of pain, but they're lucid. They're competent. They can have conversations. That's what they need in order to do that, because let's say they have Alzheimer's or dementia. They don't have the requisite capacity to be able to execute end-of-life estate planning documents. So that's one of the first questions I always ask, because a lot of times what will happen is I'll get a call from a loved one, a sibling, a child, saying, hey, mom, my brother, whomever, they got a bad diagnosis. They're going to probably pass away in the near future. They've been putting off estate planning for so long. Can you help them? And my very first question is, I will do whatever I can to help them, but we need to determine capacity first, because again, that's the touchstone. If we don't have capacity, we can't execute these documents. Now, obviously I'm not a medical professional, but when it comes to capacity, I mean, we all as humans make those determinations. I mean, I don't need to be a medical professional, Amy, to know that you have capacity. I mean, we're talking, we're communicating, we're going back and forth. Now, if we're having this conversation 40 years from now, let's say, we'd probably be speaking a little more slowly, right? But we hopefully still have that lucidity at that point in time. It's not a function of how quickly you speak. It's a function of, can you understand and process information? I mean, that's really the standard of legal capacity. Do you understand the value of the documents you're signing? Again, you don't have to recite them chapter and verse. You don't have to understand everything. The standard I use is you have to be able to, I mean, the legal standard is ability to receive and comprehend and provide that information. But for me, it's, do you understand why you're better for having these documents than not having them? That's really my standard, and that kind of gets into the types of questions that I ask before I determine lucidity. Because again, basically I'm signing a document that says, hey, these people have capacity. I need to make sure they do before I actually allow them to sign these legal documents. And it's hard. You know, sometimes I get clients who have Alzheimer's dementia. I'm like, look, they don't have the capacity to sign these documents. We can't sign these things. So again, what I recommend is executing these documents at a time where capacity is unquestioned. Do it well before it ever becomes an emergency. I always say, kind of jokingly, they call it estate planning for a reason. They don't call it estate reactionary for a reason. I mean, we do this ahead of time. We do this, and again, having that peace of mind for as long as possible. I mean, I've had a lot of clients who've been in that situation where they'll say to me, you know, I met with them in time one and they were great, and then things start to go downhill in time two, and they say, oh, I'm really glad I had these documents. I had the peace of mind for longer. So again, if you're on the fence about whether you're going to do this now or push it down the road, I would just tell you two things. One, we don't know when that end of the road is going to be, right? I mean, unfortunately, people pass away all the time well before their time. It happens. It's a fact of life. But then I guess the second part would be, it's not just mortality we have to worry about, it's capacity we have to think about as well. And having that peace of mind for as long as possible is what you achieve by completing these documents well before you ever need them.
Your hometown lawyer, Rob Melick of Melick Law, is with us this morning. Rob is always happy to take your questions, take your text messages. The studio line's open for you at 885-4446. 885-4446 is the studio line. And you can also text us at 887-9595. 887-9595 is the studio text line. Rob is an estate planning attorney and so easy to talk with about these big life things and conversations that may be difficult to start, but you really do make it easy. One of the things that you also help people understand is how to avoid probate. Yeah. It's a big deal. Like, even for someone who doesn't understand what it is, they just know it's not anything you want to go through.
Absolutely, and I'll happily talk about avoiding probate, why it's important. But one thing you've said before, and you said multiple times, and I'm glad you feel this way, is that I tend to be someone who's easy to talk to. Mm-hmm. What I will say is this: whether you're a lawyer, a doctor, a mechanic, a plumber, whatever the profession is, I can guarantee you that every single person in this room has felt talked down to at a time. You know, people using technology and jargon that you don't understand, and it doesn't make you feel great. I mean, I can tell you that. I mean, I may have a law degree, but there's a lot of areas in this world I know nothing about. And I can tell you, when I meet with a professional who has a lot of experience in that area, I want to be talked to as an equal. Or even not an equal, just they put it at my level. They're not trying to talk over me. I don't get impressed by how technical someone sounds. I get impressed by how well they can boil concepts that they deal with every day to someone like me who knows nothing about them whatsoever. So I really do strive to do that in my practice. So hopefully that's a common sentiment that people share, not only you, but my clients as well. So I hope that's the case. But as far as avoiding probate, that's really the main thing that I do with my practice. And it starts with identifying what the word probate is. Again, I'm a big fan of the hypothetical: poll 100 people at Walmart, right, or Target, pick your store, it doesn't matter, and say, what do you know about probate? Most people will have heard of the term. Most people will have a negative association with that term, as they should. But what I like to do is just boil things down into one sentence explanations. What is probate? Probate is the process where a court oversees the administration of an estate. When an estate goes to probate, there are a series of hearings, a series of filings, a series of deadlines, a series of events that occur before assets go from the name of the deceased to the name of the intended beneficiaries, which are usually the children, but not always. Not everybody has children. Some people choose to exclude their children. Some people decide to leave it all to charities, whatever the case is. But regardless of who those beneficiaries are, probate is the process, again, where it goes through the court system in order to get there. What I will tell you is this. As an estate planning attorney, my goal is to encourage my clients to create plans that are guaranteed to avoid probate. Not just possibly, not highly likely, but guaranteed to avoid probate. Why do we want to avoid probate? It boils down to three reasons. The first is cost. Average cost of probate in a state right now in the state of Wisconsin is between $5,000 to $10,000. That's an average. Some are more, some are less. The second is timing. Average length of probate in the state of Wisconsin is between 12 to 18 months. Third reason is publicity. Wills become public record. Not only does the will itself become public record, but the amount and the character of the assets become public record. Let me explain that point a little bit. Okay, I'm just use an example with my family. Like I said, I'm 42 years old. If I didn't do what I did for a living, I think there's a pretty good chance I wouldn't have an estate plan at 42. Or if I did, I'd probably have a very basic will, okay? Well, here's what I can tell you. If I had a very basic will, I am happy to share with the world what the contents of that will would be. Everything to my wife if she survives me, and if she doesn't, split evenly between my two sons, Grady and Hudson, okay? I'm happy to share that information. It's not a problem. I don't think it's really much of a surprise. Most people in my situation would probably do the same thing, okay? But that's only part of the equation, because if that becomes public record and I'm dead, I don't really care. But that's not all that becomes public record when the estate goes through probate. The amount and the character of the assets also become public record as well. What assets I had that are passing through probate. And again, with my kids being 14 and 11, is it possible that there might be some ill-intentioned people out there who are going to look at probate records, find out what these kids have, how they acquired it? Yeah, it's possible, and I don't want that to be the case. I want to go through a process where the courts never even get involved. I mean, the cost is one thing, 5 to 10 grand. The timing is another thing, 12 to 18 months. But the lack of involvement of the courts is probably the most important thing for at least somebody in my position who has minor children. So again, to summarize, negatives of probate: cost 5 to 10 grand, timing 12 to 18 months, and the fact that it's public record. That usually begs the question: how do we avoid probate? And under Wisconsin law, there are only two ways to do it, and I'm going to walk you through each of the two ways.
Okay.
One, if you take a married couple or you take or a non-married individual, right? Married couple would be the second spouse. Non-married individual, of course, would be that person's life. You fast forward to the day that person passes away, whenever it is. If at that time the value of the probate assets is less than $50,000, that's considered a small estate. Small estates avoid probate no matter what. Now, to take those two ideas and roll it back into the context of a will to make it perhaps a little more understandable, I would say this. If we fast forward to the day that a person or the second of a married couple passes away, if you have more than $50,000 worth of probate assets and you only have a will, the estate still goes to probate. Now, what's a probate asset? Any asset that does not have a named, alive contractual beneficiary, because that's one of the pushbacks that I get quite a bit. Well, I have beneficiaries on everything. My response to that is, okay, who are those beneficiaries? Usually they're children. Can you guarantee that your children are going to survive you? Of course not. You'd like to. As parents, we'd love to know that our children are going to survive us, but unfortunately, that's not the reality. We don't know that. So those assets are not guaranteed to avoid probate. They're perhaps likely or even highly likely to avoid probate, but they're not guaranteed to avoid probate. The only guaranteed way to avoid probate is, instead of creating a will-based estate plan, we create what's called a trust-based estate plan. The trust is the only guaranteed way to avoid probate because, simply put, the trust will never die, right? I don't know the order of death and dying for any particular family. I have probabilities, I have likelihoods, but I don't have the knowledge of that until, of course, those people actually do in fact pass away. What I can also say with 100% certainty, though, is that the trust will survive any human being, because the trust will never die. And that's kind of the linchpin of trust-based planning. We fund the trust. We list beneficiaries to say, okay, if this person dies, it goes here. If that person dies, it goes here. If everybody dies, we have what's called an ultimate beneficiary. It could either be generic to my heirs at law. Think of a family tree. Okay, everyone's seen a family tree. They all know about that. Every single one of us has heirs. People think heirs are children. That's not correct. Heirs can be children. They are children for the two of us and anybody who has children. But every single one of us has heirs. We just don't know who those heirs are going to be until we pass away. So we could do that generically. Or we can put in an entity or a group of entities that will never die. Charities, churches, schools, whatever the case is. Because some people will say, well, if all my children and all my grandchildren have passed away, I don't want it going to my siblings or my nieces and nephews. I'd rather go to a group of charities, and that's fine. A trust allows you to specify that. You don't have any of that customization when you have a will-based plan. You have beneficiary designations who, again, may or may not survive you. The other issue there is you don't have the protections built in through a trust. The example I give is this. Take my situation. If I relied on beneficiary designations and had a will-based plan, again, let's just say in some hypothetical world I would know that my children would survive me. I mean, I don't know that. I would never know that. It's fantasy land, but let's just assume we live there for the time being, okay? Can I similarly guarantee that neither of my children is going through a divorce? Can I similarly guarantee that neither of them is going through a bankruptcy or has some sort of addiction, drug, alcohol, gambling? The answer is no. I can't do that. If we're relying on direct beneficiaries, those children are going to get those assets no matter what situation they're in. If they're in one of those difficult situations and we have a trust, on the other hand, the trust can hold on to those assets until that situation is reconciled. So that's just yet another example I give of being in a situation where we are going to benefit from a trust no matter what. And I know there's a lot of people listening and watching today who have wills. They were told by previous attorneys, financial advisors, Susie Orman, whomever, that the will is good enough. And to be clear, wills can be good enough, but the way to get the guarantee of probate avoidance, the only way to get the guarantee of probate avoidance is to have a trust. Otherwise, it's a possibility, but not a given.
Mm-hmm. Your hometown lawyer, Rob Melick of Melick Law, is with us this morning, just like he is the third Monday of every month in the studio, and also the Daily Dodge TV studios, in addition to the Slumberland Furniture studios. You are so good in front of the camera. Again, like you were one of the first guests that we had down here and, did the stream live, and you're very comfortable, which makes me very comfortable.
Well, it's funny.
Thank you, Rob.
Yeah, no problem. I'll be honest, I don't even notice normally, except today I'm very red. I've had a lot of sun today or this weekend, so I do see myself up there a little bit.
Were you at the Brewers game when Snoop Dogg was there?
I was not, no. I was at my own son's game that day. But no, I just, with his game and just being outside in general, I'll be starting football here in a couple weeks, actually.
Can you
about 8
believe
weeks.
it?
It's flying, so.
We just got the schedule for the Packers season. Yeah.
Yes. Well, it's funny you say that. One of my really good friends from law school is a huge Dolphins fan.
Okay.
So long story short, he grew up in Pennsylvania, but Dan Marino went to college in Pittsburgh. So he was always a Dolphins fan. And the last 2 times the Dolphins have played in Green Bay, he's come out for those games, 2010, 2018. Well, it's typically every 8 years is the schedule. But the way the schedule lined up, the Packers actually play the Dolphins at home this year.
Oh, wow.
And he was planning to come out, but we looked at the schedule. It's the Thanksgiving evening game. And it's just not going to work. So they'll be playing again in Lambeau in 2026. So hopefully it's not, because that's what we were looking for the schedule when that came out. Because, depending on the time of year, if it's during football season, that's tough for me to get up there.
Sure.
With the coaching. So you want it to be a little later in the year. You don't want it to be freezing cold in like January. So like the Thanksgiving time was a good time, but that weekend, we're all with families.
Yeah.
He's with his family. I'm with mine. So we're not going to get to that one, but yeah, I'm sure I get to about a game every other year for the Packers, give or take. I mean, I don't keep track, but I'd say every other year an opportunity comes up. And I did have the ability to take my boys to their first Packer game. Well, my Hudson's first Packer game was actually Grady's second game. He went with a buddy to another game earlier, so I got to take him for the first time last year. And there was that Saints game. They came back to win in the fourth quarter. So
wow, exciting!
That was a lot of fun. So it was quite a game for their first game there. So
yeah, it's special to take the kids to Lambeau for
it
sure.
Is. Well, and it's one of those things where it's like we balanced it out because there's a lot of cursing and in general debauchery in the stands.
Oh.
So yeah, so it's one of those things where it's like I don't know if I want like a 7-year-old exposed. I mean, people parent how they want to parent. I'm not judging, but
it's different between the Packers games and the Brewer games that we've enjoyed together.
Goodness, yes. I mean, the Brewers games. It's just. I mean, you can sit next to any Yahoo anywhere, but some of the stuff I've seen and heard at Packer games. I'm like, yeah, I don't know if I want my kids exposed to that. But like I said, we went up there last year and they were 13 and 10. That's a little more reasonable.
Yeah.
I mean, they know all those words at this point, and it's just kind of the way it goes. And they understand drinking. They understand that kind of stuff a little bit better. So, and in fairness, we sat in a great section. We didn't really have any issues. The issues were kind of a little down and away from us. So I didn't really have to explain any things I didn't want to explain to my kids. So it was a good experience, and they won, most importantly. So.
Yeah, lots of sighs of relief there. You don't have to explain things you don't want to. We get a win. It is all good.
Absolutely.
Your hometown lawyer, Rob Melick of Melick Law, is with us here in the Slumberland Furniture Studios and also the Daily Dodge TV studios. Rob is an estate planning attorney and really does make things so simple to understand. You make it so easy for people to have a conversation and to meet with you. Please share all those ways that folks can get in touch with you for that initial appointment or to have existing documents revised.
Absolutely. So my phone number for all of my offices, again, via phone or text 24/7, 262-347-3444. Again, 262-347-3444. For most people in the listening and viewing audience, my Beaver Dam office would be the most proximate. Sandy and Matt over at Hire Insurance let me use their office in Heritage Mall next to the Joanne Fabrics there. But I do also have office locations in Richfield, Port Washington, and West Bend. I do also make house calls as well. So if there's mobility issues, if there's inclement weather issues, I'm happy to come to your home. Also virtual meetings as well. I have some people who prefer to use that technology of Zoom or FaceTime, phone call, whatever the case is. Happy to do that as well. A couple final points there is that no matter what situation you're in, whether you have those existing documents or whether you're looking to start from scratch, I do always offer free initial consultations. And that's not just a perk of listening to this station or watching this. I offer free consultations to everybody. But what is one perk of listening or hearing this or seeing this is that I do offer a 20% discount for WBEV and Daily Dodge listeners/viewers. So if you do elect to create an appointment based upon seeing this or listening to this, just let me know and we'll happily take 20% off the bill for you.
Excellent. Thank you so much, Rob, and good luck with your interview
Thank you.
and your photo for the paper later today.
Thank you, Amy. I'm excited. It's one of those things where it's kind of a monument. I didn't think I would get here this early, to be honest with you, but the right building came up, and we're looking forward to moving in.
Well, good luck with
you.
everything. Always a pleasure. Rob Melick of Melick Law, your hometown lawyer, with us here this morning. This has been a paid program. Advice and opinions expressed during the program are solely that of Melick Law, not WBEV or Good Karma Brands.